boy Corey tuned in. Thank you for everybody tuning in another episode of the Hood Paralegal Podcast. Today, I'm going to be talking about deliberately convicting the innocent, and exonerations and how they expose the criminal justice system and the callous indifference toward the official misconduct. And thank everybody for tuning in and all the support you've been giving. And if you got any comments, please share them, like, and spread the word on social media. And if you know anybody that's been wrongfully convicted, please share their story in the comments and give us some details, because this is a trending topic, but not even a trending topic. This is a pandemic in itself. So I'm gonna start off with some statistics. 70% of official misconduct the report found was committed by a combination of prosecutors, 30% law enforcement officers, 35% of those, and forensic scientists and analysts, and that comes down to 3%, and child welfare workers, which is 2%. Now, the report didn't include any misconduct by judges or defense attorneys, although many instances of misconduct from them came to light as a result of pursuing claims of ineffective assistance of counsel. Now, official misconduct occurred in about 1,296 cases, which is 54% of the 2,400 exonerations that was examined during this study. And the overwhelming majority of those detected misconduct occurred in prosecutions of violent crimes. Now, this is due in part because most exonerations, about 78% of them, were for violent felonies, including both those with misconduct and those without misconduct. The following table shows the number of exonerations for each type of violent crime where misconduct occurred at the rate of occurrence of misconduct for all exonerations of that crime. And then that table basically just lists murder, manslaughter, felony, assault, attempted murder, arson, child sex abuse, kidnapping, sexual assault, and robbery, which are some of the violent crimes. Now, first, there's an increased pressure on the public officials to solve these serious crimes, so community demands to a greater extent to know who committed a murder compared to knowing who broke a few windows in the parked cars. And that increased pressure may lead to a rushed effort to solve the crime that is highly susceptible to misconduct. Then second, the conviction for a more serious crime has a greater chance of a more thorough post-conviction investigation that will uncover misconduct. For example, the amount of time and other resources spent on post-conviction investigations of murder convictions, especially those resulting in the death sentence. Now, simply, those aren't convictions for lesser offenses that resulted in a few years in prison or probation. Now, examining the 5 general categories of official misconduct, almost all of the official misconduct identified fell into 5 general categories. Number 1, witness tampering. 2, misconduct in interrogations. 3, fabricating evidence. 4, concealing exculpatory evidence. And 5, misconduct at trial. Now, this episode, I'm just going to brief on the first one, which is witness tampering. I'll give you some examples. Harold Franks, age 59, was shot and killed in the 1975 robbery in Cleveland, Ohio. That also left bystander Ann Robinson, who was 58, seriously wounded. Now, police quickly identified 2 suspects, Paul Gardenshire, which was 16, and Ishmael Hickson, which was 23. Now, however, police suspended investigating them when 12-year-old Eddie Vernon came forward to say he had seen the shooter, whom he identified as Ricky Jackson, who was 18, flee the scene in a car with his brothers, Ronnie and Willie Bridgman, who were also 17 and 20 respectively. Now, the thing about this case is no physical evidence tied the men to the crimes, and none had a criminal record. Now, in fact, the car seen speeding away from the scene was actually traced to Hickson. Nevertheless, they were convicted and sentenced to death, which was later commuted to a life in prison sentence based almost entirely on Vernon's eyewitness testimony. And remember, Vernon is a 12-year-old. And after a journalist investigating the story tracked him down, Vernon recanted. And he eventually testified at the 2014 hearing that he had not witnessed the crime. In fact, he said he heard a rumor that the 3 men were involved, so he invented the lie because he wanted to help the police. Now, Vernon further testified that he tried to recant before the trial, but the police threatened to arrest his parents for perjury if he changed his story. Police never revealed any of this to the court or the defendants. And this is a common occurrence. You hear it every day. It's something new, and this is a common occurrence. Now remember, in regard to this case, at that same hearing, evidence was finally presented that Hickson, one of the original suspects, pleaded guilty in 1976 to more than a dozen aggravated robberies. And Gardenshire, the other original suspect, had been convicted of the same crime in 1978. Now, later in 2014, the three men sent to prison for Frank's murder were exonerated. But by that time, Ronnie Bridgman had been paroled after serving 29 years. The others were still in prison, having served 39 years, and all of them as innocent men. Now, witness tampering happens when witnesses are induced to provide false evidence or withhold accurate evidence. In 325 of the 409 cases in which witness tampering was identified, the defendant was wrongly convicted of murder, sexual assault, or child sexual abuse, and in 80% of those cases, the tampering was carried out by police officers, with the remainder carried out by prosecutors and child welfare workers. Witness tampering was generally accomplished by threats occurring in 130 of those exonerations and manipulation occurring in 305 exonerations. Now, these threats included telling witnesses that if they did not cooperate, they or their close relatives would be charged, sentenced to prison or death, lose custody of their children, etc. Now, manipulation generally involved paying witnesses with money or other valuables, promising leniency in their own criminal cases or release from custody, as well as other benefits. But manipulation also included convincing witnesses that the defendant...
All calls other than properly placed attorney calls may be monitored and recorded.
Based on evidence that didn't exist, and convicted them that the defendants would go free without the witnesses' false testimony. Now, these three types of common witnesses tampers that may be accomplished either by threats, manipulation, or both. Number one, procuring false testimony. Now, that's the practice of inducing a witness to testify to the facts the officer or prosecutor knows the witness did not proceed, which is a common occurrence in today's legal system, which they call AKA justice. Then you got the tainted identification, which occurs when police deliberately induce a witness to identify a suspect during a lineup or other identification procedure, whether the witness recognizes the suspect or not. And number three, you got the improper questioning of a child's needs, which occurs when the child is repeatedly, insistently, and suggestively questioned by a government official who will not allow the child to deny that he and she was a victim of sex abuse. And then you got another example. For example, this guy named Rondell Adams, his car ran out of gas in Dallas in November 27th of 1976, and he was given a ride by a 16-year-old named David Harris. Later that night, when 37-year-old Adams was no longer with him, Harris was shot and killed by a police officer. Once the teenager became a suspect, he claimed that Adams had been driving and shot the officer with Harris' gun. Because Harris was a suspect himself, police needed a credible witness to make the case. Now, our witness described the shooter as black or Mexican, and Adams is white, failing to identify Adams in the lineup. But then, the officer promised to drop pending robbery charges against the witness' daughter if she would change her statement and make the identification. Wow. All of this was concealed from the defense, but not the prosecutor, and the witness testified at trial that she identified Adams unassisted. Adams was convicted, later sentenced to death in 1977. Now, 8 years later, a documentary filmmaker dug into the case and discovered that Harris had subsequently received a death sentence for another murder, a sentence that never would have occurred but for the false testimony given by a witness at Adams' trial. In 1988, Harris recanted his testimony against Adams, who was then exonerated the following year. Harris was executed for the second murder in 2004. Now, this is a prime example of misconduct in our justice system and dealing with witness tampering. And like I said, it goes on a lot, especially with children. If you're a parent and your child is wanted for questioning, do not force them to talk to the police. They have rights, and they should not question your child without you being present. And do not get the impression that when you tell your child to talk to the police and tell the truth, their truth is not the definition of your truth, and then twist it and turn it around and make it something else. So you got to know your rights. You got to know what's going on and stay on point. And I look forward to y'all tuning in to next episode. We're going to be talking about more misconduct and the misconduct that goes on in interrogations. Thank you all for tuning in. Have a blessed week. Like I said, anybody got any stories of witness tampering, any type of misconduct regarding our injustice system, please feel free to comment and let us know, because this is dialogue that we want to talk about. We got to put it out there because, like I said, it's a pandemic of injustice and it don't get talked about enough. Thank everybody for tuning in. Have a blessed week, and remember, riches and poverty are an offspring of the thought. I love all y'all. Have a blessed week.